So, coming to Indian legal system, the law on conciliation, there are various legislations which suggest it, and success rate of these conciliation concepts in different legislations differs. Family Courts Act suggested conciliation. Industrial Disputes Act in 1947 also suggested conciliation along with other authorities to resolve the dispute. Now, if you look at these two legislations, there is one common feature in these two legislations, that is early resolution of dispute is one of the basic requirement of both the laws. Industry needs to function peacefully without any disputes. So, therefore, there is a need for resolution of dispute at the earliest point. Families needs to exist without any disputes. So, therefore, there again we need an early resolution of dispute, and most importantly the resolution of dispute should be through an amicable conciliatory process. The other legislations like Civil Procedure Code also proposed conciliation, that is section 89 of CPC. Arbitration Conciliation Act, that is what I had mentioned in the earlier slide, that it is an influence of international community which we also passed the legislation in 1996, and they are the major backbone for arbitration and conciliation in India. And the latest addition is Consumer Protection Act, which also established the Conciliation Council, which is going to deal with the disputes in a conciliatory manner. And in my presentation, instead of taking all the legislations, I would be taking discussion on Arbitration Conciliation Act and Industrial Disputes Act. Let me start with Industrial Disputes Act. If you go through the legislation, they do not bother to define what is conciliation. That is again a major indication that conciliation is not a new concept. Legislatures felt that there is no need to define conciliation, as it has already been understood by all the legal stakeholders in India. But when you go into section 4, where they define what is the role of conciliation officer, they use the following language. They say conciliation officer is charged with duty of mediating in and promoting the settlement of industrial disputes. So, here what conciliator is supposed to do is mediate between the parties. See, the legislatures have asked conciliator to mediate, means they are the words which could be used interchangeably. So, that is what I was trying to tell you, that international community already have moved ahead and they tried not to take up this discussion, the distinction between conciliation and mediation. They already accepted it as interchangeably used. Indian community or Indian legal system, still we are calling with two different names, and there is inconsistency in approach. So, I will leave this discussion at this stage, because I have to cover the more basic things in this. So, therefore, is conciliation and mediation one and the same? Is the role of mediator and conciliator is one and the same? The answer is may not be identical, but it is mostly similar. Some technical distinctions have been made by some of the authors, but they are again not to be taken into too seriously. So, when we establish a conciliation officer under Industrial Disputes Act, the Act suggests various powers and functions for the conciliator. So, again I will draw your attention to earlier slides. We are talking about the role of conciliator, and everywhere it is written he is only an enabling authority. He is only an authority who is going to suggest. It is the parties who should agree. It is a friendly manner of bringing out an amicable settlement. So, in these situations, when conciliator is not a deciding authority who cannot enforce any of his views, what is the use of these powers? Are these powers are going to be the major hindrance in achieving settlement agreement? Let us look into those powers first. So, he Conciliation officer being a facilitator, mediator, and he is a promoter of settlement, he is given certain powers when actually parties are in the driving seat. Conciliator is not at the driver's seat, but it is the parties. One of the important power which conciliator enjoys is power to enter any premises and conduct investigation. So, when he enters a premises, conducts the investigation, comes up with the facts, comes up with evidences. What are the use of these facts and evidences? He is not going to decide anything. Second important power is to conduct inspection. He can conduct inspection of the premises, documents, etc. What is the use of all these powers when section 21 of Industrial Disputes Act clearly prohibits from using those information which is collected during conciliation in any other proceedings. So, whatever information is collecting has to be kept with himself. Whatever information is collected cannot be used in conciliation, and it cannot be given to any other authorities for their use. So, therefore, these powers have been given without much thought. The other powers is power to enforce attendance of a person. Now, here interesting thing is they use the term person. So, when you use the term person, we are excluding one important aspect, that parties are not included within this enforcement of attendance. When we say person, we are talking about the persons who could appear as witnesses, and they could be called for two purposes. Purpose number 1, to appear and depose before the parties about certain important information. Purpose 2 would be appear, produce certain documents which is there in their custody. So, in these two purposes, I find this is an interesting and important power, because clarity as to facts should be achieved before we proceed with the conciliation process. Then conciliation officer is a deemed public servant. He has all the protection of section 21 of Indian Penal Code, very well, most required, because he would be immune from all the proceedings connected with the conciliation. So, these are relevant powers which are enjoyed by the conciliation officers. Then coming to power to conduct the conciliation proceedings. So, whenever there is a dispute in an industry, conciliation officer is supposed to conduct conciliation proceedings. Is it mandatory or is it optional? The answer is, it is optional in every industry, because it is a conciliation officer who decides that whether it is worth to be conciliated or whether the dispute is of such nature that it should go to adjudicatory authorities. But if the industry qualifies to be public utility service, a service which general society would be directly affected, there conducting of conciliation proceedings becomes mandatory. So, therefore, power to conduct conciliation proceedings is mandatory as well as optional, depending on the nature of industry where the dispute has occurred. Reporting of conciliation proceedings. Now, there is one important authority under Industrial Disputes Act called appropriate government. When the dispute arises, the appropriate government takes up the dispute and refers it to the relevant authorities. So, conciliation officer supposed to make a report and submit it to the appropriate government, so that it can take an appropriate action on the report. So, whenever a conciliation officer conducts a conciliation proceedings, he would come up with two possible outcomes. One, successful conciliation, other one is a failure. When conciliation proceeding succeeds, then he is duty bound to draft a memorandum of settlement, get signed by all the parties, countersigned by the conciliator, and submit the memoranda to the appropriate government. So, that is the end of the dispute, that is the end of the proceedings. Sometimes conciliation officer fails to come up with the settlement. In those circumstances, the conciliation officer is supposed to prepare an elaborate report about what kind of steps he took to resolve the dispute. Along with the steps, he also has to mention brief set of facts and circumstances which led to the dispute. And then comes most important part of the report. Along with these two informations, he has to give a information as to full statement as to the reasons why they could not come to a settlement. When you say why they could not come to a settlement, means there would be a blame on one of the party who had not agreed with the settlement, who has not agreed with the proposals, who has not agreed with the options. In these situations, it becomes very difficult for a conciliation officer as well as the parties for the conciliation to proceed with other authorities. As I mentioned in the earlier slide, that section 21 of Industrial Disputes Act prohibits conciliation officer from sending the information to any other authorities. Here is a rule, here is a section which makes it mandatory that the conciliation officer must reveal the details of the conciliation proceedings, why it failed, who was the cause for the failure. I find that this information that is required under this section should not be allowed, because it goes against the basic tenets of conciliation proceedings. So, once the report is given to the appropriate government, the appropriate government takes suitable action. So, why the failure report should contain those informations? Now, here is one justification. I will leave it to you to decide whether it is a good law or bad law. The reason for submission of all the details is that appropriate government is going to decide what to do next. The next step of the appropriate government depends upon the report, because there are 4 kinds of authorities under Industrial Disputes Act. Like conciliation officer, there is another persuasive authority who is only pursue the parties to come to settlement. He is an enabling authority. There is inquisitorial authority who conducts investigation, cause for the problem, other details could be covered by that. There is a coercive authority like arbitration, like labor court, industrial tribunal, who force the parties to be abide by the award pronounced by them. Then there are preventive authorities who come into action before conciliation officer, because they try to prevent the dispute. So, looking into these different authorities, the appropriate government needs to check the nature of dispute, who is more suitable to resolve the case should be assessed. As there is one more persuasive authority available after conciliation officer, it is necessary for the court to know whether there is a chance of settlement and whether that additional authority could be utilized. That is the reason they ask for all the details of conciliation proceedings. They are not using it to decide the case, they are using it only enabling them to decide on further future steps.